Good evening. Welcome to another edition of The Law and You. My name's Joe Moless. I'm Dean of Lincoln Law School of San Jose. And ordinarily when I host the program, I can say that I'm doing so because the regular host, Stuart Fahmy, is away. Today I can't say that, or this evening. Mr. Fahmy is here with me, and I'm having the pleasure of interviewing Stuart Fahmy, your host of The Law and You. Welcome to the program, Stuart.
Well, thank you, Mr. Moless. It's a pleasure being here, and now I feel quite different sitting on this side of the show. But I appreciate very much you being the host tonight, and I look forward to your questions.
Well, a number of people have asked me about you, and I think it's appropriate. You've had this program for many years to tell the viewing audience a little bit about Stuart Fahmy.
Well, as you know, I was educated, born and raised in Cairo, Egypt, educated at Cairo University with a bachelor's in science. I immigrated to this wonderful country of ours in 1970. Prior to that, I worked for a couple of years in Congo, teaching at the University of Congo, and pursued a career in law here, got my law degree from Lincoln Law School, got an MBA from Pepperdine University, took quite a bit of courses in negotiations at Harvard Law School and Harvard Business Law School, and took an LLM from Golden Gate University, have been an attorney for over 20 years, a real estate broker, have been acting as a pro tem judge for years and doing a lot of arbitration and helping the courts here in their alternative dispute resolutions, better known as ADR, and married with 2 children, and have a lot of interests in other areas that I won't bother you. But before I start, I would like to thank you personally. For people that don't know our relationship, it started by knowing you as my professor at Lincoln Law School. You taught me corporations, you taught me constitutional law, not law school, and I'm very grateful and appreciative of your help throughout my career. So I want our audience to know that.
Well, I thank you, and I can tell the audience something that's perfectly true. It's not ordinary for a professor to count a student as friend, but we've been friends and colleagues from the time I taught you, and it's been very rewarding for me. Stuart, I understand that you have a particular interest and love and expertise in alternative dispute resolutions, ADR. Would you briefly describe how ADR fits into our system?
Yeah, generally speaking, people think when there is a dispute of the courts and the legal system under the litigation process as their only way to resolve their disputes. But throughout the years, and lately more so than before, people and the courts have been looking for other means of resolving disputes. Hence the idea of alternative dispute resolutions, or ADR. And rather than the costs and the time and the emotional stress that usually goes on with litigation, other resolutions ways have been used, namely the arbitration process and the mediation process. And generally speaking, arbitration involves a mini trial type thing whereby generally, not necessarily, but generally an attorney will resolve the dispute between the parties on a much more informal setting. It's less hectic, it's less emotional, it's usually much less time spent on resolving the dispute, but the arbitration decision or the arbitrator decision at the end is final and actually can rarely be appealed unless there is some sort of collusion between the arbitrator and one of the parties, or something really out of the ordinary. And the judgment rendered by the arbitrator is enforceable in any court of law and is final, as I said. Another way of resolving disputes is what we call mediators or mediation. And that is a much less formal situation whereby an attorney, generally speaking, or a mediator like myself, would work with the parties trying to resolve their disputes on a shuttle type type business. I mean, they go from one party to the other, find out exactly what the issues are, what's each party's strong and weak points, and try to bring the parties together. They, generally speaking, know each other. There is some sort of a closeness in what they're trying to achieve. In other words, mediation would not be appropriate if one party is asking for $1 million and the other party is offering $1,000. And then it's almost impossible to resolve these kind of issues. But when the parties are close enough, then mediation acts very, very well to finalize the dispute and get the parties on their way.
How would you choose one form of ADR over another? Arbitration over mediation? You suggested that one might be the amount by which the parties are apart. Are there any other
well, yeah, I mean,
predicates?
If they're not close, or if they believe that very strongly in their case, whereby I want $1 million and not a penny less I'm going to accept. In this case, mediation may not be effective, but arbitration would be the best way of arriving there. Also, if there is a lot of emotional stress between the parties, if the parties can't stand each other and cannot really see the point of view of the other party, then arbitration is probably more suitable for this kind of disputes. You want a finality. You don't want to spend all of the money that you would generally spend in litigation or in a court trial, whether it's by jury or by judge. But one want to cut down on the time. Mediation is more so, as I said, when the parties are close, they know each other, it's much more informal, and they don't want a finality to it at this time. Possibly if they reach an agreement, they will be final, but they want to leave the door open to other forms of other, either through the court system or through arbitration.
Stuart, the president of the State Bar, Howard Miller, has indicated that there's a great concern that the legal system is for the rich and the poor. The rich because they can afford counsel, and the poor because government provides counsel. Is ADR particularly attractive to the great middle in resolving their disputes rather than full-blown litigation?
You raise an excellent point, and you're right on. Absolutely. When the parties are not either on the rich side or the poor side, then the middle class people, or the people that are of limited means, not necessarily poor means, may find either arbitration or mediation their salvation, because they can resolve the issues real quick. They don't have to go through, again, the emotional strain and drain that they go through in a litigation setting. And they finalize their disputes one way or the other, either through mediation or arbitration, without having to spend a tremendous amount of time and money in getting their problems resolved.
You're one of the most respected ADR leaders in our county. Would you tell me, if you operate in the role of recommending, what cases do you recommend for mediation?
As I said, personal injury cases are perfect for mediation, whereby the parties know exactly the extent of the injury. Actually, believe it or not, family law matters are excellent for mediation, whereby the husband and wife don't want to spend all the money on two different attorneys, and the law is very clear on how they have to split their properties and the custody of the children and all of these issues. Then mediation will work wonder for